Hello, welcome to COVID-19 and the Law Colloquium. I'm Martha Minow, and I give my thanks to so many members of the Harvard Law School community for making possible this colloquium. Dean Manning and today's participants, absolutely indispensable. On this Veterans Day, we all thank our veterans for their service. This session is recorded so we can post it on the website along with the recordings from all prior sessions and other informative resources and blog posts available at covidseries.law.harvard.edu. Emily Broad-Lieb and I developed this as a forum for discussion of the many ways in which legal rules and practices are tested and are responding to challenges brought on by COVID-19, and also to examine how the pandemic shines a spotlight on the inequities, frailties, and failures system-wide in legal frameworks and institutions, with especially burdens falling hardest on marginalized communities, notably people of color, people who are impoverished. Over the course of this fall, the weekly colloquium has addressed basic needs, government duties, elections, economy, and finance, legal rights and needs of people in detention, housing and food access, employment, consumer protection, immigration. And next week, our last topic, will address topics that we haven't had a chance to even touch on and open up new discussions about the treatment of animals in agriculture, slaughterhouses, police accountability, environmental and energy issues. Today, we have an absolutely critical discussion: access to courts, agencies, lawyers, legal help, and innovations. We are enabled by Ellie Benet, who's here today, even though the staff have Veterans Day off. And there are opportunities for students to follow on today's discussion with small discussion groups tomorrow, and the information about that is being made available to you. The access to justice issue has always been a problem in the United States. We've never had adequate mechanisms for people without resources to enforce their rights or pursue important changes. But it's worse now than it has been even in the recent past. Just as an example, 40 years ago, the Legal Services Corporation, the major federal source of funding for legal services on the civil side for low-income people, funded many more dollars per capita than it does now. In 1980, there was one lawyer funded for every 36,000 eligible people, and now it's for every 61,000 people. There are great benefits from making sure that people have access to justice, not only for their own self, not only to enforce rights, not only to reduce and avoid human suffering, but to save financially for everyone else. And yet that argument has not persuaded the country to do more. And it doesn't even touch more profound barriers in government systems, rules that are incomprehensible to anyone without legal experience, rules against the assistance by non-lawyers, background rules that advantage employers and landlords and sellers rather than employees, tenants, and consumers, the legal system's insensitivity to the challenges of in-person hearings, and so forth. These failures have been totally laid bare during the pandemic that expose the underlying life issues and the legal system defects. But at the same time, this period has exposed how possible change is. Virtual hearings, waivers of in-person application requirements, new digital tools being made available, many possibilities, and we're going to explore it all here with the ideal panel and the ideal moderator. John Hanson is the Allen Stone Professor of Law. He created and directs the Systemic Justice Project and also the Project on Law and Mind Sciences here at Harvard Law School. His teaching and scholarship integrates psychology, social cognition, economics, history, and law. Beloved teacher and section leader, he creates community and challenges systemic injustice every day. He'll introduce the outstanding panelists and lead to a vital discussion. John.
Thank you so much, Martha. I really appreciate it. And that's a wonderful setup for today's panel. I will not attempt to replicate it. I'll get right to it. But first, I want to say thank you to you and Emily for inviting me to moderate and participate on this, and to inviting this amazing group of panelists to join us today, and for putting together this remarkable and important series. This is really a special panel for me, I think, because the panelists are all simply extraordinary. They're all among the lawyers, colleagues, and people who I most admire in the world, and really proud to call them all colleagues. Um, I'll tell you briefly who they are by name and title, in alphabetical order by last name. Esme Caramello is a clinical professor of law and the faculty director of the Harvard Legal Aid Bureau. Jim Greiner is the Honorable S. William Green Professor of Public Law and the Faculty Director of the Access to Justice Lab. Dan Nagin is a clinical professor of law and the Vice Dean for Experiential and Clinical Education, as well as the Faculty Director at WilmerHale Legal Services Center and Veterans Legal Clinic. Lucie White is the Louis A. Horvitz Professor of Law and Director of the Harvard Law School Ghana Project. And David Wilkins is the Lester Kissel Professor of Law, the Director of the Center on Legal Profession, and the Vice Dean for Global Initiatives on the Legal Profession. There's so much to say about each of them and the valuable work that they have been doing and continue to do. But because time is short and the panel is large, I will resist the temptation to tell you about how great this all-star panel is in order to preserve more time to hear from them about their work. And to that end, we're going to just, we've posted the links to their bios so you can learn more about them, as I'm sure you will want to do if you don't already know about them. My plan is to lead a discussion for the first 35, 40 minutes or so among the panelists. We've had enough time to chat beforehand to say we're all committed to leaving time for Q&A. And as audience members observe and think about questions, I would ask that any questions you do draft for the Q&A, that you include the name of one or perhaps two of the panelists to whom you'd like to direct your question to help us get more questions in that portion. So let's begin. Lucie, if I may, I'd like to begin with you and to talk about some of the work you've been doing in Chelsea, where you've been looking at the implications of COVID-19 for vulnerable communities there. And wondered if you could tell us a bit about that work and what you think lawyers can learn from close listening in communities like that that have been hardest hit by the pandemic.
Thank you very much, John and Martha and Ellie and everyone who participated in this. This is a real honor. As John said, I want to talk about listening, why it's an important part of what lawyers need to do in distressed communities, particularly in these times. More specifically, I wanted to talk about listening in Chelsea. Chelsea is a city in the greater Boston metro area with several distinguishing features. It's one of the state's smallest and most densely populated. It has one of the highest percentages of immigrants, many of whom are undocumented. It has the lowest per capita income. It's a site of toxic waste and ongoing pollution, one of the highest portions of essential workers in the COVID context. And it has a history that includes the construction of the Tobin Bridge, near bankruptcy, street violence, and more, and the highest COVID infection rate in the state, 6 times the state's average. Yet it also has a dense network of community initiatives, from environmental to community gardening to childcare co-ops to worker organizations to Latinx youth groups, an overarching community collaborative, and the presence of a very strong organizing initiative. I got to know Chelsea in the context of the pandemic through work I did last summer. It was a project in which we looked comparatively at 6 hotspots across the US, and a description of that is posted as a website on the course blog. In the project, we started by looking at existing epidemiological research, and that showed that the unequal health outcomes in Chelsea were mostly caused by overcrowded housing and workplace virus exposure. Building on that, we did a multi-step process. The first step was just to listen carefully and holistically without any prior specific advocacy goals. We listened to health workers, religious leaders, leaders of community, organizations, and more, people who knew the community well. And we heard many stories. Overall, we heard that people were overwhelmed and scared of infection, of eviction and deportation, of having no food and income for their children. We heard that in that state of mind, they wanted someone to hear them, not just what they were facing, but how they were coping and how they were working together. We repeatedly heard a paradox, and that is that even though they knew separately about all the advocacy organizations working in Chelsea, they didn't put them together. And in spite of that spread of services, they felt entirely alone. They also had specific stories to tell of landlords who wouldn't accept rent assistance, which in the landlord's interest, because the landlords wanted to evict them to clear the way for gentrification. 11-year-old child caring for 2 toddlers and an aged relative on her own, virtually locked into her house because she was afraid to go outside. An essential health worker riding with unmasked fellow passengers on the jammed 111 bus across the Tobin Bridge before dawn every morning to work in a hospital laundry without childcare at home. Community members not knowing about 2 childcare centers for essential workers right in Chelsea, about free access, even for undocumented people for certain COVID benefits, about free sites where individuals could quarantine away from home. And everyone, particularly undocumented, was in constant fear. If I seek Medicaid, even if I'm documented, I'll risk deportation. If I go to a testing site, I'll confront what they perceive to be armed guards. If I take my kids outdoors or let them outdoors, I'll get caught. Such listening in our project was the first step in a sequence of advocacy steps. After the listening, we did a mapping of what we heard against background laws and political forces of every type and every jurisdictional level, not just related to COVID or public benefits. Based on that and what we learned about advocacy, we linked together all the advocacy organizations that were already operating in Chelsea. This is the proposed way forward. We only got to the first and second stages so far in the project after a summer's worth of work. We linked up. The next stage would be to do community education about the linkages among all the advocacy organizations and how people could access them, then filling in frontline service gaps like filling out rental applications by mobilizing volunteers from student organizations across campus, identifying low-hanging fruits of law reform, like improving the rental application forms, which I know that organizations like the Mass Law Reform Institute are working on already, but those low-hanging fruits can actually be seized. And then charting longer-term advocacy projects, such as fighting the way that municipal development plays into gentrification and the way that okay, I've got one more thing to say. The way that transportation plans also promote gentrification. Over the summer, the project just got off the ground. Our hope is that the method can be just one tool of community-anchored transformative advocacy during COVID and beyond. Thank you very much.
Lucie, that's amazing. Such wonderful work and such a sort of a restatement of the lesson of life and law, that listening is central to our being effective, to working with and for others. It also seems to be exemplifying the model of community and movement lawyering that is having such a big impact right now. And I'm so happy to hear about the work you're doing. Dan, I wonder if you might talk a little bit about your related work in the Legal Services Center, where you've been doing anti-poverty lawyering, and share with us perhaps what you're learning about the implications of the pandemic for technology and anti-poverty lawyering. And if you have a moment to speak to whether and how listening and community engagement of the sort that Lucie described plays a role. If you don't have time for that, you can leave that one off, Dan.
Thanks so much, John, and to Martha and Emily and everyone else for putting together such a fabulous series. An American Academy of Arts and Sciences effort was launched last year and endeavored to document, shine a spotlight on, and rally responses to the access to justice crisis in this country. This landmark project, co-chaired, of course, by Martha, included a recent report that mapped the problem and highlighted an array of all hands-on-deck strategies to tackle the crisis meaningfully. And this was all begun before the pandemic, when we already knew that 86% of poor people's civil legal needs received either no or inadequate legal help. So because of the depth of need, there are lots of ways to think about access to justice in the time of COVID-19. As John said, I want to focus on one angle. That angle is the role of technology, which is an area of particular interest for me. Our community-based clinical program, the Legal Services Center, is home to civil legal representation clinics across 6 different practice areas. We've been doing a lot of telephonic and Zoom hearings, and our students have just been incredible and creative in their efforts on behalf of clients. I want to make 2 points by drawing from the center's current docket. First, in a time of isolation and deep anxiety, we must find innovative ways to reach people who may not so readily be able to find help. The digital divide is an enormous, enormous hurdle in this area. And as Lucie's comments powerfully show, navigating systems and resource networks is a monumental problem for poor people. So new technologies targeting civil legal needs must be part of that response. And yet, even something as basic as phone contact is fraught. We've learned as the end of the month nears, too many of our clients have to cut down on how much they even talk to us over the phone, isolated as they are, because the minutes on their cell phones are starting to run out, and they must ration their time and their minutes and make difficult choices about what conversations they can even have as they seek help in every direction. So even as we experiment at the center with various outreach tools and community legal education over Facebook in partnership with the Boston Public Library, loaning iPads with Wi-Fi hotspots to clients to help them be represented by us, thinking that online presentations and new apps and shiny tech tools are going to solve the problem of access to justice, it's misguided. It's a part of the response, but certainly cannot be the response. And then second, I want to leave you with a story about one case. I think it's worth sharing here because it shows that while the digital divide and inequality have posed enormous challenges for people in need, there are also some unexpected moments of possibility too around technology's use in the current moment, and with lessons for the future. In addition, I think this vignette highlights one of the challenges in the very concept of access to justice. When we say access to justice, do we just literally mean access? That is just some kind of procedural justice or ability to meaningfully participate in a process or respond to a legal challenge? Or do we also mean substantive access to justice too? That is just outcomes. The following shows, I think, how much we can and should insist that access to justice must mean both. So the center is home to the Project on Predatory Student Lending, which fights predatory for-profit colleges and their enablers in the Department of Education. The project is co-led by my incredible colleagues, Eileen Connor and Toby Merrill. Their team, together with dedicated clinical students, have been on the front lines of this pioneering area of consumer law. I must note that the following is entirely secondhand and comes courtesy of project attorney Maggie O'Grady, who was counsel at the hearing I will describe. And I want to thank the project for giving me the privilege and opportunity to share this story. Here's the setting. A Zoom hearing conducted by a federal district court judge in the Northern District of California. The project had brought a national class action suit against the Department of Education for failure to process what are known as borrower defense claims. These are defenses to school loans in connection with for-profit colleges that had defrauded students because the schools themselves were shams. People of color were often the primary target of these schools. The court had already certified a nationwide class action of 160,000 members, and the project represents the class. A hearing on a potential settlement agreement was scheduled for and did occur on October 1st, 2020. Pre-COVID, this hearing would have been in person in the Northern District of California. During COVID, of course, it takes place over Zoom, and that would change things a bit. So now class members from around the country don't have to travel to San Francisco to participate, which they probably wouldn't have been able to do given their financial distress and the cost and burdens of travel across the country to participate in a process. They could now participate from anywhere in the country, even just using a smartphone in their pocket or joining during a break at work. So instead of just a few class members being able to join, now many more could. Over 500 class members logged into Zoom. 15 were chosen to speak. And then something incredible unfolded during the hearing. While the designated class members testified over Zoom, all the other class members began conferring with each other in the Zoom chat function. They started to share stories. They created a sense of power and momentum. They collectively supported each other in the Zoom chat and responded to the shame and stigma of being defrauded. Among other things, they also started to share denial letters they had received from the department and were able to show the court in the chat that the boilerplate denial letters they had received were a sham. And I'm going to do a very quick screen share just to give you a sense if I have a moment. And John, you will tell me if I do not. Let's see. I will not do a screen share because it's not showing up. In any event, I will tell you that the Zoom chat included a whole bunch of students conferring with each other and sharing stories and quoting the language in the letters they had received from the department, showing the court that the entire process was a sham. And they wouldn't have been able to do that except for the Zoom chat that had brought them all together. In the hearing, the judge actually said, after seeing all this information in the Zoom chat and hearing from the students, I have been a judge 21 years now, and I have done a lot of class action hearings. And this is the most interesting one of all because over 500 people tuned in, way more than you would ever get in a normal class action. And we have done it so that people can show up from all over the country. It is quite amazing. The Zoom chat was actually entered into the record. It's a document in Pacer with a docket number. And according to Maggie, this is the first known instance of a Zoom chat at a federal court hearing being entered into the record. And the judge's order that followed was a slam dunk for the plaintiffs. That the entire hearing and the Zoom features of the hearing had a remarkable outcome remarkable impact on the outcome, which would have never been possible with an in-person hearing. The judge actually used the term shared trauma of the plaintiff class in his order to describe their victimization by predatory schools. You don't hear that every day in a consumer class action. So some very brief takeaways. There are some assumptions that courts moving online creates barriers for public interest lawyering doing anti-poverty and racial justice work. Absolutely true in many, many respects. But the project and predatory student lending case highlights some unique and unexpected opportunities can arise too in an in-person hearing. It would have been harder to be heard, to share and build community, to tell a powerful story. And so through the Zoom hearing, there's some new possibilities about the future of aggregate litigation and public interest lawyering and building community. As the judge said in his order at the end, and this was meant as the highest compliment to Eileen and Toby and the project, this is not an attorney-driven case.
Right.
Thanks, John.
Thank you, Dan. That was wonderful. Such a great example and story. In some ways, I feel it echoes Lucie's point about the ability to listen to a community, the tendency to listen to community. In some ways, technology and the way we've done things has prevented us or insulated us from hearing voices of those who are directly impacted. And although technology is certainly mixed, as the lessons you highlight make clear, there are opportunities in this space to bring voices otherwise to each other that are otherwise separated, and to the law, which are otherwise unheard. That example is terrific. And if I have a moment at the end, I'll draw a kind of parallel story in its implications for legal education. But first, I'd like to turn to those who might say a little bit more about kind of what this may mean for the future, and what are some of the larger sea changes that may be underway. And there is no better person to ask that question of than David Wilkins, who has been studying the sea changes in the legal profession ever since I've known him 30 years ago. So David, I wonder if you can just take that setup and give us 4 or 5 minutes on what's happening out there.
So thank you, John, and thank you for reminding everyone that I was teaching long before you. Thank you very much. Listen, as the Chinese would say, may you live in interesting times. We're in the midst of 3 crises, all related: a global health crisis, a global economic crisis, and an increasingly global calls for social and racial justice. And all 3 of these are exposing the kind of deep structural challenges that were already going on before the pandemic. There's a really important new book by Harvard Business School. She's actually a university professor named Rebecca Henderson, called Reimagining Capitalism on a World on Fire. And what it says is that we have been living in a world of kind of extractive capitalism, in which a smaller and smaller percentage of people were extracting a bigger and bigger percentage of resources, and that is fundamentally unsustainable. I want to just talk very briefly about the implications that this has for the legal profession generally, and I'm just going to briefly mention 5, all of which we're studying at the Center on the Legal Profession if people are interested. First, we're moving from a world in which we thought about globalization as a kind of unstoppable force, and one in which the pandemic absolutely shows the interconnectedness of the world, and yet the differences in the response to the pandemic show the importance of the local level, whether that's national, state, or even at the city or municipality level. And that means that lawyers are going to have to become glocal, as I say. They're going to have to understand how to put global and local together. Second, we're moving in a world from technology we thought of as being disruptive to pervasive. I used to have to convince lawyers that technology was going to change their lives. Now we're all living on Zoom. And we're not going back, even if there is a vaccine, and Zoom is just the beginning. What we just heard brilliantly from Dan Nagin is technology can have lots of important benefits, but we also know, as we're living through this, that it's incredibly harder to build community and collaboration online in many ways. And most importantly, to avoid burnout and to have wellness. You know, we're not working from home, as a WAG said to me, we're actually sleeping at work. Third, we're moving from a world in which we can only think of ourselves as lawyers delivering legal services to delivering solutions to complex problems at the intersection of law, business, technology, politics. Again, this was going on before the pandemic, but it is only going to be reinforced by it. The good news is we're going to need great lawyers more than ever. There's been an explosion in law and legal problems, but lawyers are going to have to help their clients understand how to create solutions, not just to provide legal answers. Fourth, we're moving in a world in which we no longer just think about kind of business enterprises as about shareholders, to one in which fundamentally we have to think about sustainability. This again was going on before COVID, but by underscoring the deep structural inequalities, COVID and the protests are only accentuating this trend. And if you have any doubt, the World Economic Forum, Davos, said that we need a, quote, great reset of capitalism in the wake of the pandemic. I think it's fair to say that in many ways, green is the new black. Some of you will get that joke. But now we understand that sustainability has to be linked to social justice. Corporate America has been pouring billions of dollars into things like supplier diversity initiatives, social justice investing, board diversity initiatives. And we need great lawyers to understand how to make that money work effectively, because now black is the new green. So here's what I want to end with. The future belongs to you. Amidst all the changes that have happened in 2020, here's one that escaped many people's attention. Gen Zs, okay, not millennials, Gen Zs, the first of them graduated from college in 2020. And we now know that millennials and Gen Zs already make up 38% of the workforce and will be over 50% in a little more than a decade. That means that your generation is the generation. And I have no doubt that your generation is going to be as profoundly shaped by the events that are happening today as my parents' generation were by the Great Depression and World War II. And on this Veterans Day, we should remember that that greatest generation transformed the world. And I have no doubt that you will too. So here's the deal. When faced with crises, people can either retrench to the standard way of doing things, or they can rebuild and reimagine what things should be like. And here's what we know from history. Fortune favors the bold. So be bold. Thank you.
David, that's going to be tough to follow, my friend. That was really informative and inspiring. And even though I'm not a Gen Xer, I am feeling inspired and ready to go. Thank you so much for that. So we're talking about making some historical lemonade out of the lemons in which we find ourselves trying to navigate. Esme, you have been doing work on Massachusetts state courts and thinking about the way in which they should be and could be reshaped in light of all that we're learning and some of the dynamics that David just described. I wonder if you could share with us some of what you are working on and what you've learned.
Thanks, John, and thank you so much, Lucie, David, Dan. I mean, for those phenomenal, thought-provoking presentations. I'm happy to say I don't have to try to follow David in a David style, because I'm going to share something that's a lot more narrow and a little bit intimate, because there's just so much going on from an access to justice perspective that you kind of have to figure out where to go with your 5 little minutes. So I, for a number of years, have been a member of the Massachusetts Access to Justice Commission. And in a normal time, what we do, among other things, is we just sort of gently pester the courts to innovate and to make themselves more accessible to people who don't have lawyers, people who face other barriers to equal participation in court systems. And so when the pandemic hit, like everybody else in the country, we created a COVID-19 task force. And we did that because we knew that the court system was going to have to completely reinvent itself, definitely in the short term, because courthouses were closing and all sorts of things that we used to rely on, like the mail and people signing things and handing them to other people, and those people taking those things to buildings and filing them, were not going to happen. So in the short term, for sure. And we also sensed, of course, that short-term changes were going to lead to long-term changes, whether anybody liked it or not. So we realized we got to get in there and make sure that that the needs and rights of people without lawyers and people who face barriers to equal participation in court processes were protected as the new rules were being rewritten. And we also realized, there's an opportunity here, because if the court system is sort of being thrown up in the air, you don't know where it's going to land. This is a real opportunity to influence it and figure out, influence where it lands while it's in flux. And partly, I think that that sense of opportunity was really a sense of optimism, like, okay, here we go, we're making change, let's go, this is what we've been trying to do for years. And as I reflect on where we are now, which I'm going to share with you in a second, I think that was based on a theory of change in the access to justice space that was probably wrong. I think that I was operating on the assumption that a lot of the reason that we were not making what seemed like very obvious, sensible changes to improve access to justice was just inertia. Like, court staff are busy and they're kind of used to doing things the way they're doing them, and they think that they're sort of mostly working. So while they recognize that maybe an improvement could happen and might happen, it's sort of like hard to find the time and the motivation to do those things. But that inertia was totally knocked out by the pandemic, right? So now we're making change, and the question is, what change are we making? So with the rest of my 5 short minutes, I want to share just a little story from housing and tell you where I've sort of landed in this little meditation on access to justice and change in access to justice. And it's a story from housing, which is where I mostly practice. I mostly do eviction defense. And going into the pandemic, we had an eviction system that was pretty dysfunctional. And you don't have to take it from me. You can take it from the Massachusetts Supreme Judicial Court, which issued a unanimous opinion in 2019, very long, groundbreaking opinion that outlines all the problems with our eviction system. But briefly, it's a system where the law is extremely complex and it's located in all sorts of obscure places, very hard to find. The cases move extremely quickly. The deadlines are very, very strict. And on top of all of that, so it's very difficult to navigate without a lawyer. And on top of that, the vast majority of landlords have a lawyer, and there's no right to counsel for tenants facing eviction. And the vast majority of tenants do not have a lawyer. So you also have this imbalance in access to that resource, that incredibly valuable resource, the lawyer. Dan mentioned sort of outcomes. One outcome that we know is that in 98% of the judgments in eviction cases, 98% of the judgments go to landlords. That's not the only statistic. There's a lot more that we could talk about on another day, but you know, there's something here that says, okay, we need to change this system. Well, here comes the pandemic. The system's in the trash. The system's getting changed because you cannot, first of all, we had the courts shut down and then we had an eviction moratorium. Between those two things, eviction proceedings were almost entirely stayed for 7 months. So now you have 7 months of backlog and you have unprecedented housing instability right now. You know, 300,000 people in Massachusetts, we think, are facing immediate housing instability due to COVID-19. So you have this huge number of cases and you have the backlog, and now the courts are reopening. They simply can't do it the old way. Plus we're all remote and the housing courts are basically staying remote for the meantime. So now what? This is the new system. We think this is a great opportunity because, for example, the old forms, which were impossible to read, which we've spent years talking to the courts about improving, they're in the recycling bin. We're creating all new forms. So now that we're creating all new forms, let's run them by a plain language expert. Let's translate them into multiple languages. Let's make sure that they're written at a 3rd grade reading level for all the people who are coming into the court system who don't have lawyers. Let's make sure that they provide people with information about legal information so that they can navigate the system on their own, knowing that they don't have lawyers. All of those things have been actually remarkably hard to accomplish. Things that seem very simple, very obvious, and very inexpensive have been extremely difficult to accomplish. On the other hand, what we did accomplish is this. Governor Baker invested $11 million in counsel for tenants. He sort of created a little mini right to counsel in eviction cases, which is something that is absolutely transformative, that would have seemed radical a year ago, and now we have it. So you can do that, but you can't get the form to be translated into Spanish. So I've been reflecting on what is this? Because if it was just inertia, and I am wrapping up, if it were just inertia, that wouldn't explain this outcome. And it's definitely not that the court system isn't full of good and committed people. So my current working theory is this. When you make change in any system and in the court system, it alters the balance a little bit, right? It changes something. So when you make a change that benefits somebody, it either disadvantages somebody else or just removes the advantage that somebody else had. And in doing so, it sort of shifts the balance of power. And I think that there are a lot of people in the court system, if not the vast majority of them, that feel that the highest duty of the courts is to be neutral. And it can be difficult to persuade, and I hear this again and again as we're bringing up these, well, let's make this plain language. It's not neutral. It's not neutral because it shifts things a little bit. And we might say that's exactly where we want our courts to be. We want them to be neutral. But I'm also reminded, especially in the wake of the very tragic death of our fantastic, amazing Chief Justice, Ralph Gantz, who was a huge access to justice hero. You know, I'm reminded that in the words of Howard Zinn, you can't be neutral on a moving train. So I think a challenge going forward is how to reimagine this question of the role of the courts and the neutrality of the courts, where coming into the system, there are these vast inequalities and the court is sort of operating in that context.
I think that was wonderful. I've got a few analogies running through my head, including the fast moving train and non-neutrality on it. Also thinking about your comment, what was radical a year ago is no longer radical. And in some ways, I think that also speaks to David's point about the magic of this moment and some of what this generation has in front of it, the opportunities, but also, you know, the fraughtness of it all. Anyway, so happy to get that example and hear about your work and some of the triumphs and difficulties. Some of what you spoke about really is in the wheelhouse of Jim Greiner, who's up next. And Jim, I kind of feel like you can just start right where Esme left off and run with it.
Absolutely. So thank you, Martha, Emily, and Ellie for the excellent panel. Thanks to John and the panel members for a terrific panel. And I am going to start right where Esme, you left off, which is what are some innovations that the court can pursue in order to try to make it more accessible and to resume its functionality. And I'd like to focus as an example of those, the challenge of resuming jury trials. Because I feel like as though if the court system can solve that challenge, then it can probably solve most other challenges that it is facing in terms of resumption. Why is it so important to think about resuming jury trials? Number one, the criminal system is jammed up right now. People are spending lengthy amounts of time incarcerated pre-disposition because they cannot get to their jury trials that they have demanded and want and feel as though they need. And the only way to get out is to plead guilty, which they don't think they want to do. And second is because the court systems have generally prioritized the criminal system. And so the civil system is jammed up until the criminal system gets reopened, which is facing the problem of, again, running the jury trials. I want to suggest that online may be a response to this, and we may be able to actually hold online jury trials. As echoing Dan, online and technology can't be the total response, it can be part of the response, which is what I wanted to chat about here. Why would it be important to try to resume this kind of thing? Well, because we have to reopen the courts. If we don't do that, we can't have people vindicate rights that they need to vindicate. So it might be one I think response might be, well, if the courts are jammed up, that means people are not getting evicted because evictions are shut down. As Esme is just suggesting, that leads to a gigantic backlog. And again, it also leads to people not being able to vindicate rights that they want to vindicate via the court system, including low-income people who need to use the courts. This harkens back to a study that the Access to Justice Lab and I completed a couple of years ago on a desire to get divorces in Philadelphia. And basically, people came to legal services organizations wanting to remarry, wanting to organize the few possessions that they have, and they wanted to realize who they are by getting divorces. Basically, we heard, I don't want to be married to that bum anymore, over and over again. And they can't do that until the court system reopens. They can't do it without a lawyer, which is what we found out in our study. And they also can't do it without court hearings in some cases. So what are the problems associated with the sort of ultimate challenge of holding an online jury trial? Well, one thing is that in a pandemic, a jury trial is a super spreader event. It just is, as soon as you hold one. I mean, all you have to do is get a public health expert and say, hey, public health expert, I'm going to get a bunch of people from a cross section of the community and bring them into a poorly ventilated room for 3 hours while we go through a process in which they ask questions. And then I'm going to dispense with most of them because I don't need most of them. And I'm going to send them back into their communities after they have spent 3 hours together in a poorly ventilated room and traveled to get there, and watch the public health expert just give birth to a cow. Because that's exactly what the public health expert would do. This is a terrible idea in a pandemic. It may not be a good idea, quite frankly, in a place other than a pandemic, when we emerge from the pandemic, because there may be advantages to doing things online if we can. So what are some challenges that we face? There are a series of technological problems that some of which have already been highlighted, but also the technology provides an opportunity. And I'll just point you once again to Dan's story on how the technology can increase access. It could also increase access to jurors, to would-be jurors, who may in some cases be unable to take days off in order to attend a jury trial in person, but may be able to arrange to do so remotely. You do have to address the digital divide, but maybe this is a space in which courts can take a page out of Dan's description of saying this is our responsibility. So Dan mentioned that the Legal Services Center was sometimes providing mobile hotspots and iPads. Maybe the court needs to say, you know, access to justice and participation in this is our responsibility, and this is something we need to be doing. We need to protect, for example, attorney-client confidentiality. This can be done with technology. There are a series of challenges legal challenges, purely doctrinal legal challenges in the criminal setting, centering around the confrontation clause. But I think it's pretty well established in current confrontation clause jurisprudence that in some sort of compelling public interest situation, which I think the pandemic would qualify, given the steps that we've taken to address pandemic challenges, that the right of the defendant to confront the witness may actually be preserved, because you could actually have the defendant and the witness in the common room, but there maybe we can dispense with the right of the defendant to be in the physical presence of the jury. Which has ever been a core understanding of the confrontation clause. Of the right to confront the jury is different from the right to confront the witness. Then there are a series of objections and challenges that I want to provocatively call lawyer and judge angst. So defense attorneys, including ones that I've recently had conversations with, want to see jurors and witnesses. They want to see them testify because they think they can read the jury's faces, the jurors' faces, and they think that they can see the way witnesses are reacting and tailor their questions accordingly. Judges want to believe that that jurors who are in the physical presence of witnesses can detect deception at a higher rate than if they are, say, online or if they are reading a transcript. And here, I think the science can help us. What science we have available? Let's use deception detection as an example. The science, there is actually a fair amount of science on whether people can detect deception better in person or better online or better reading a transcript or better simply with no visual cues whatsoever and listening to an audio recording. And it turns out that what the science teaches us is that there are very, very few differences on our ability to detect deception in these different settings. It's not because human beings are good at it in any of these settings. It's actually because we are so astonishingly horrible at detecting deception that the format is essentially irrelevant, that basically human being deception detection cannot climb above 54%. 4 percentage points above a coin flip. And so with that in mind, I think this is an area in which both the science and the technology can inform the reactions that the courts take to the pandemic, respond to the pandemic. Again, if we can solve online jury trials, we may be able to solve even bigger problems. So I'll stop there.
Thank you, Jim. That was great. That statistic is unbelievable, but I guess that's part of the problem. Really appreciate that. And I'm just going to try to say a few words about the work that I've been doing. And then let's, in the meantime, I'm hoping we'll get some questions from the audience. But I just want to say what a great panel this has been. I'm hoping you all will continue the conversation if we have a couple of minutes today, but if not, after this. I would like to echo some of the language I've heard from some of you to say what's inspired the work that I've been doing with through the Systemic Justice Project, through, among other things, the COVID-19 Rapid Response and System Summer Institute over the summer that engaged about 250 lawyers and 70 legal organizations around the US to try to get them together and also to build some programming around questions of justice. And then this year, initiating with Justin Hansford, who is the who is at Howard University Law School as a professor and also runs the Thurgood Marshall Civil Rights Center there, where we have come together to build a kind of national classroom of sorts, though I don't want to treat it as if it's a class. It's a community, and in many ways, it's class in the way that Dan was speaking about the class that emerged somewhat spontaneously by their common presence over Zoom, and discovered in that space a number of similarities and commonalities of experience. And my sense of this project is a reflection of something that both Justin and I feel, which is, and this is not news, law is a part of the problem in many ways, just like technology, it's mixed, and legal education has traditionally been and is to some degree mixed. It is part of the problem. It can be part of the solution. And going to Jim's point, part of what we're trying to do as legal educators is what I think lots of institutions are doing and individuals are doing right now, which is that this is our responsibility as a legal educator. What can we do to better sort of address the way in which legal education is contributing to some of the problems, some of the fires that David Wilkins spoke of in our system. And so we have created that and have learned a great deal through listening to students and lawyers who are doing this kind of justice-centered systemic work, and including community lawyers and movement lawyers of the sort that Lucie's example to some degree illustrates, but also listening to the range of experiences from students and the commonalities of their experiences. And in many ways, I think they are getting better legal educations where they're at, but they're learning a great deal about how to think about legal education, their own careers and laws from that. And that is all possible in part because Zoom has made us relatively good in this space, though I think many of us would like to get back to the classroom. With that, I'm going to say, let's get to some Q&A and wonder if I might see here. Yes, I'm getting some now. So this is a question from Marty Strauss to Professor Greiner, and it reads as follows. Even with low deception detection over any format, do you think video jury trials might increase the false positive? In other words, might juries think they see deception more often because Zoom can make communication more awkward and stilted than in-person communication? If so, what might be some ways to mitigate that?
So short answers, there's no science to suggest that it's more likely that you have false positives than false negatives with respect to deception detection. And what science there is suggests that there's no, across different formats of communication, the science that there is suggests that it appears to be equally likely across formats. That doesn't mean that false positives and false negatives occur at equal rates. That's different, and that's not true. But the format doesn't appear to make any difference as far as we can say. In addition, if it is true that there are false positives or false negatives, it's still not clear at higher rates. It's still not clear which way that cuts in terms of whether that's pro-defendant or pro-prosecution. So many defense attorneys think that if I can't have witnesses, my witnesses are less likely to be believed, and it's going to be anti-defendant, it's going to be pro-prosecution. But it's the prosecution that typically has to put forward more evidence and have its witnesses be believed. And so this is something that, again, I think we'd lack information on, but right now the science that we're encountering is not showing much of a difference in terms of false anything. Again, this is not saying same rates, but false positive, false negative, but the format doesn't appear to make a difference in terms of people's reaction to deception.
Thank you, Jim. So looking at my next question, I've got one from Martha for David. Is there any chance of making the great ideas you put forward of interest across political parties, geographies, and so forth? Good luck with that,
Martha,
David.
that's not true because you answer questions that only you can answer. Listen, this is a moment. I just want to say this is a moment, and Martha and I, she won't mind if I say, are old enough to have lived through many of these moments in which interest in these issues kind of waxes and wanes. And so I think it's incumbent on us to take advantage of this moment. Here's what makes me hopeful about this moment. I think we're recouping what I like to call the Brown dividend. And that what I mean by the Brown dividend is Brown versus Board of Education, as Martha knows, since she wrote a brilliant book about this, changed the world. And one of the ways it changed the world was in terms of who got access to elite education around the world, and particularly here in the United States. And the people who went to school on the wings of Brown are now moving into positions of significant power and authority in many places, including corporate America, where we would not have think of as being a change agent. And what they are doing is using their substantial power inside corporate America to push for change and to enlist allies. And the thing they're making, which is, I think, the most persuasive argument, is what Rebecca Henderson, after all, she's a business school professor writing a book that says it's unsustainable, the way in which we've been doing things. And as our graduate Ken Frazier, and a dear friend of mine and Martha's as well, says, you know, the workplace is the one place in our echo chamber society in which you cannot fully choose your cohort. You can't just, you can choose your neighborhood, you can choose your school, you can choose your cable TV channel. You cannot fully choose your workplace. And that's why I think people in these, who run these workplaces, are thinking about these issues in a way that they haven't before. I'll just say one more quick thing that I just want to plug. We've got, there's been all this great work to talk about online courts. And we've got a big conference on online courts that we're doing virtually on the 20th, which we'll put in the chat. But Martha, thank you for embarrassing me by not being able to answer your question.
Martha's questions are always very difficult. That's why she asks them, of course. And by the way, David, love that answer. You're more optimistic than I am about your work, which I'm a big fan of, and also more optimistic about the kind of change that is going to be brought about through commercial interests going forward. And I think that's also something fundamentally, in my view, has to change with respect to the circumstances in which corporations are operating to make a difference in kind of the way they behave in a way that is fundamental enough to make us hopeful. So I want to add a little pessimism to this group because I don't want to end on an up note if I can avoid it. Question one more here in the last 2 minutes. Anyone know what's going on in other countries and that what they may be doing to address access issues that might be employed here?
John, just 10 seconds. Other countries have been moving to online courts before the pandemic. In major ways, including movements across the water to say that all matters below a certain amount in controversy are presumptively online unless the court orders otherwise. And that was a cost saving and supposedly, depending on how it's implemented, access to justice measure that was being taken before the pandemic. So that's just one innovation.
That's great. Anyone else want to add anything? Esme, were you about to unmute? Well, I'm gonna close it up. We're supposed to be done at 1. I'm just gonna take a moment to say what a great honor it was to be asked to moderate and be part of this panel by Emily and Martha again. And I couldn't be among more sort of thoughtful, insightful, and sort of changers on our faculty. It's just really, really great to have this opportunity to connect with you in this world of being separated. It's been a really special privilege just to see you all and to hear you talk about your work. And I'm wishing all of those I can't see on the other side of the Zoom all the best in their work. And my guess is, based on what I know about these faculty members, they would all be open and eager to hear from you if you had questions about any aspect of what they're doing. So I encourage you on their behalf to reach out to them.